Welcome to the INREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, good morning, everybody. Welcome to the show. Today, our topic is That's a Wrap Agreement. We're talking about wrap agreements. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, give us a like. Make sure to subscribe to our YouTube channel. We would appreciate it. Give us a like, subscribe, and that allows us to provide you more and better content. With that, Sean, why don't you give us our legal update for today?
Yeah, so today I want to talk about situations in which investors have gone from investing in real estate, or real estate ownership, leasing of real estate, those types of things, and they've ventured out into making loans, predominantly second position loans. And as the market shifts, and nobody has a crystal ball, and I'm not making any predictions, but as we do see, maybe a slowdown forthcoming, or even having started, we're going to have investors out there who are going to have second position loans, and the borrower / owner is struggling with the project, or struggling with the property, and maybe goes ahead and defaults on the existing first position loan. So what does that mean for that second position lender? So 2 weeks ago, we had Andrew Bang on, and he talked about hard money loans, and that their goal is to try to never have a default, but in the rare circumstances, they're trained to deal with it. So what does that mean? How do you deal with it as a second position lender if the first position defaults? So I'm speaking here under Arizona law. I imagine, especially when you're dealing with deeds of trust, the laws of other states where deeds of trust exist is going to be similar, but nevertheless, consult an attorney.
Or maybe it's not even deeds of trust. Maybe it's just mortgages.
Right, yeah. Exactly. But in Arizona, the second position lender has a lot more rights than what they think they do. We always hear about the idea of, oh, well, I can't get any information from the lender. They won't release anything, all these privacy laws, et cetera, et cetera. Well, in Arizona, we have specific statutes that require trustees. So when a property goes to foreclosure here in Arizona via a deed of trust, a trustee who's been appointed by the deed of trust or who later substitutes in, they are empowered to sell the property. And so they record a notice of trustee sale, and there's a 90-day period between the date that the notice of trustee sale is recorded to the date of the sale. They have to wait those 90 days. And so during those 90 days, a second position lender has the ability to obtain significant information regarding the loan, and even, take steps to bring the loan current, those types of things. So they can contact the trustee and say, I want reinstatement figures. And what reinstatement figures are figures that the trustee has to provide when there's been a monetary default under the loan, and the loan hasn't reached the maturity date yet. They have to provide a number that the borrower or the property owner or even the second position lender can pay. And it's not the full loan balance. It's basically the default amount plus the cost for the trustee's fees. They can pay that amount and bring the loan current and bring the loan back into good standing. And a second position lender can go to the trustee and say, hey, I'm the second position lender on this property. I have a lien interest in this property. Statutorily, I have a right to those reinstatement figures, and provide them to me. And the trustee has a very short window and time frame in which to provide those reinstatement figures. And then the second position lender has the right to go and basically write a check to the trustee and bring that loan current. Well, why would the second position lender want to bring that current? Well, if there is equity in the property and the second position lender, or maybe they're even experienced with you know, fix and flips, development, managing investment properties, maybe that second position lender thinks, okay, if I bring that first position current and then I do my own trustee sale, right? Because now they're definitely, if they haven't already missed payments on the second position, they're in default because they didn't keep the first current and the second had to pay out to bring the first current. And so the second can then go and do their own foreclosure. And so basically they would need to, keep the first current, or at a minimum, keep it current long enough that they can beat them to the sale. Because you have, the second still has to wait those 90 days. They beat them to the sale. And then since they're second position, it's likely if they bid it right, that they'll end up being the owner of it. They can do whatever they need at that point to the property to obtain their equity or obtain the payment on their loan, a substantial payment on their loan, and basically try to recover as much as they can of their loan from that property. So that's one. Second, maybe there's a plan in place where the owner is going to be able to somehow turn the ship around and rescue the property. Maybe a little more dicey, but nevertheless, it's still a possibility. And if the second is working with the owner, they could then reinstate and then give the owner some more time or additional opportunity to try to make something of the property. Then the second position lender also has the ability to simply go and pay off that first position loan. And in that case, they could obtain payoff figures from the trustee, and statutorily they're required to, the trustee is required to provide those payoff figures, and then they can go and pay it off. And it's kind of the same concept. Do I want to keep it current or do I want to pay it off? And now my loan moves into first position on the property. I can then foreclose on the property. And of course, because you've paid it off, that's going to be added to the loan balance. And so you'll have a hefty credit bid, and you might end up not having to worry about dealing with the first, keeping the loan current, those types of things. You can just pay it off and move on. Or you may be, as a second position lender, want to negotiate a short payoff with the first if you think that there can be something there. And, because like when we talked about with Andrew, they don't want to foreclose. The last thing they want to do is own a property.
Right.
So maybe they say, okay, yeah, we'll forego some of the default interest. We'll forego, some of the trustees' fees, whatever the case may be, and you negotiate a short payoff. And then once again, your loan then moves into first. But you're entitled to that information. You're entitled to reinstatement, you're entitled to payoff, and you're entitled to take steps to protect your security by making the appropriate payments that you deem from a business perspective to be appropriate.
And two things I'd add to that. If you are a second position lien holder entitled to that information, when I've served as trustee on trustee sales, I can tell when I'm dealing with a sophisticated lien holder who does this. But you want to ask for this information early. The sophisticated lien holders, and just because you ask for the information doesn't mean you're going to do anything with it. You may do nothing with it, but I'll send out notices, and I can tell that within days of usually those notices going out and getting to their recipients, I'll receive requests for that information. So get it out early. So this is on the front end of the 90-day period. So you're not waiting till the last minute to try to make things happen on a wish and a prayer with only days before the trustee sale. And two, do it in writing.
Mm-hmm. Oh yeah.
Do it in writing.
Right.
Yeah. I mean, if you call, sometimes you can call, get the trustee on the phone, and maybe they get it and whatever else, but the statute's pretty clear.
Yes.
That the trustee's obligation to provide you the information depends upon a receipt for request in writing.
Correct. Yeah. So it's one thing to call up the trustee and say, hey, I need these figures. Okay. They may or may not provide them to you. But to invoke the statutory right to those, you have to send it in writing and follow the statute as far as the mailing requirements. That's for sure.
Yeah. All right. Good information. With that, we're going to get into the substance of our program today, our main topic. And today we are talking about wrap agreements. And to discuss wrap agreements, we have with us today Texas attorney T. Alan Ceshker. Alan is, as I mentioned, an attorney in Texas, and here to discuss that with us. Alan, thanks so much for being with us.
I appreciate it. I appreciate it. Happy to be here. Seen y'all's podcast quite a bit, so quite exciting.
Yeah, we appreciate that. Alan, tell us about your law offices.
So we're a law and title office. I say law and title office. 95% of our work now is focused around title work, and the law office is just here to support that title work. And so we close files in Texas throughout the state, and focus on a lot of the creative type of stuff, like mortgage wraps, like we're discussing today.
Tell us how you became involved in the real estate investor community and doing this kind of work.
So I was a construction litigation attorney, and so kind of a natural progression. My construction client said, "Hey, why don't you close our transactions?" I said, "No, we don't do that." And then one client sold a $3 million house. Litigation occurred. I saw the settlement statement and saw what the premiums were. I said, "Hey, we close transactions now," and so we kind of built around existing clients back in 2003 or so, and then became kind of a full operating title office in 2007.
So right now, what appears to be hot in the real estate industry are creative finance transactions. Maybe not your standard typical transaction that the viewer might be used to. We're hearing about subject to transactions and just a variety of different creative finance transactions. And specifically today, we're talking about wrap agreements, which we know you have experience with. Why don't we start at the beginning for the kind of the casual real estate investor? What is a wrap?
So I've wrestled with this definition for a long time, and I finally came up with a very succinct statement of a wrap or a sub-to is simply the seller finance of a property that doesn't pay off the underlying mortgage. And I emphasize seller finance just to try to get folks demystified, make it simpler. It's just seller finance. Ignore the fact that there's an underlying mortgage, at least initially, to understand what these things are. But just seller finance where the mortgage stays in place.
Jumping from there, beyond what it is, when are you most commonly seeing the wrap used?
The most common is going to be in distressed seller foreclosure situation. Am I breaking up a little bit?
Yeah, broke up just a little bit, but we got you back. Go ahead and start again right at when you typically see it used, a wrap agreement.
Okay, but most often is in the foreclosure situation, distressed seller situation. Another very common one is probate matters where there's a deceased owner in title. But I always say a mortgage wrap transaction is possible when you have a situation where the seller does not have to pay off their mortgage to get to their next living arrangement. So if you're on MLS and you see for sale or lease, that can be a mortgage wrap. But any distressed seller situation is the most common.
So understanding that it is not your typical conventional transaction, your typical conventional forms and agreements aren't typically going to suffice for something like this. So what kind of documents, in your estimation, are necessary for a wrap?
So in terms of the contracting, I always advise you use the state promulgated forms as much as possible. So you have your seller finance addendum. We're going to use those for mortgage wraps. Let me tell you a distinction I draw between terminology. I call mortgage wraps any type of transaction where the mortgage isn't paid off, but then I drill down and call the sub-twos or assumptions when the purchase price is exactly what's owed. So I'll sometimes say wraps for all of them and sometimes say subject to when we're talking exactly about a situation where someone's purchasing a property for the exact amount of the payoff. But I always advocate for using the state promulgated forms as much as possible. And then you'll have some state disclosure and federal disclosure forms that need to be filled out. But as long as you get everything encapsulated in the contracting with the state promulgated forms, a knowledgeable title office will help after that point. And then in terms of the loan documents, it's a full loan package where you have a promissory note, deed of trust, warranty deed with vendor's lien, and then again some associated disclosures, both required and just ones that I think are helpful. But we try to use the normal documents and have a as normal transaction as possible. So when it's reviewed later, if it's reviewed later, it looks like just a normal seller finance transaction.
Hi, Alan. Thanks again for being with us today. We really appreciate it. So when you're doing a wrap, it sounds like you deliver the purchase contract to title with, the seller financing terms as part of it. You can use the state form, which along with the seller financing addendum, you send that into title, and then title's going to do a little bit of the back end work. But is title insurance available for a transaction or a purchase using a wrap?
Title insurance is possible on all wraps other than FHA and VA. You may find some underwriters occasionally, either knowingly or unknowingly, providing that insurance on those. But if they were asked directly, every underwriter is going to say no in regard to FHA and VA. There's a reason for that stems back to 1990, where HUD came in and said, don't wrap our loans. And then someone got in trouble, in fact, in 1990. And ever since then, 32 years ago, underwriters have said, oh, dear Lord, let's don't insure those. It's too dangerous. But other than those, we insure all wrap transactions. And you don't have to get title insurance. So sometimes folks are closing without the title insurance.
So what documents, as far as your office, when you're handling the closing of a wrap, will you prepare? Will you prepare the deed of trust and note as part of that transaction, or do you require that to be done separately from, buyer seller's own counsel?
So I prepare all of the loan documents for mortgage wrap transactions that we close. Since there is title insurance most often, I don't close wrap transactions that have mortgage wrap documents, loan documents prepared outside of my office. And additionally, I don't prepare mortgage wrap loan documents for files closing in other title offices. And the reason is because while simple, there are some mandates and there are some necessary items that folks may not know about. I always say mortgage wrap transactions are kind of like tying your shoes. It was very, very complex at one point in time, but once you do it a few times, you know how that's done. But an average escrow officer, if you ask them, hey, can you close a mortgage wrap? They're going to say, yeah, absolutely. And then they try to learn it on the go. And I don't want to be involved in that.
Right. What are some of the federal statutes that come into play in wrap transactions?
So that's a big question. I'll tell you what they are. We can't drill down. I'll do an order of time. We got the SAFE Act, Federal SAFE Act, that started out. It kind of said, hey, if you're doing more than three of these, three of these things, let's go ahead and use a residential mortgage loan originator. And that's a company that comes in and determines credit worthiness of your borrower. Just make sure that they're able to repay the loan. Then in Texas, next came the T-SAFE Act, which was a little bit more restrictive. And then the Dodd-Frank Act, the famous Dodd-Frank Act, came in. And dear Lord, we were all in uproar and scared about that thing back in, I think it started January 2015, and it became kind of a dud. And then here in Texas, we had some new legislation January 1 of this year called Senate Bill 43, and it came in and it put some teeth in what the SAFE Act was trying to do. And so while it was suggested you use a RMLO, residential mortgage loan originator, this new legislation came in and said you will be using an RMLO after your third one. If you don't, then borrower has right of rescission, can get damages. So it's toothy now.
So well, I shouldn't say obviously, generally, if you have a seller who's listed their property for sale, or, you know, just looking to unload the property, maybe an estate or trustee of a trust, they can, under both federal and it sounds like Texas law, they could do it without a loan originator because they're only doing, you know, one every 12 months or something like that. But it does sound like mortgage loan originators need to be involved if an investor, as part of their disposition strategy, is then going to do their own seller carry with a wrap. What does a closing look like once a mortgage loan originator is involved in that? And are there mortgage loan originators in Texas who, you know, kind of specialize in, you know, handling these seller carryback transactions?
So the closing looks substantially the same. We're just going to have some documentation from the RMLO in regard to it's called confirming ability to repay and getting the 1003 and all of those items. So it's going to look more like a conventional mortgage, but you know, for us, substantively still the same type of closing. And then there are some RMLOs who are more familiar with providing the services for a seller finance transaction. In terms of specializing, well, I guess I'll give those people, yes, they're specializing in that just because they understand what's going on more. Sometimes we'll get an RMLO that doesn't understand this. They're saying, hey, you can't use the old HUD settlement statement. You need to use this closing disclosure, and you don't have to, but we go along with them.
Okay.
Alan, are there particular types of loans, so existing loans on the property, that just don't work for purposes of a wrap agreement?
The only one would be a reverse mortgage. A reverse mortgage, you're going to be increasing your payoff amount monthly, so you wouldn't want to wrap that on a long-term basis. We have seen a reverse mortgage wrapped on a short-term basis for a fix and flip type situation, but reverse mortgages are not going to lend themselves. And then situations where private lenders, very small banks, some credit unions, they will actually come in and act on the due on sale clause, which I'm sure we'll talk about, the most talked about item of a mortgage wrap transaction. So you do need to watch out. If you have a private lender, you say, hey, can I wrap this? And you get an assumption agreement signed off on. You're not going to get that from the credit unions or the small banks. So you do need to be wary of who your lender is. If it's the big banks, they don't care about the mortgage wrap, but if it's a private lender, they very well might.
So some of this might depend not so much on not so much on the law as much as who you're potentially dealing with. Is that right?
Yeah. The law, as long as you have the correct disclosures and utilizing an RMLO now, the law is a non-issue. And the law is protecting the borrowers, so it's only dealing with the seller side of the transaction, as you indicated. If you have more than 3 per 12-month rolling period, now you got to start complying. Also doesn't apply to commercial transactions, just residential. But once you have the disclosures, then the only difficult part is making sure everything is set up correctly and managed correctly. And that's where it's extremely important to make sure that the title office you're working with is preferably, I always say preferably owned by an attorney, and an attorney who is rolling their sleeves up and getting dirty in the trenches, and they know this work. If it's just an office that's going to use the state promulgated mortgage loan documents and then toss you out there in the wind, that's going to be more dangerous.
Who are the monthly payments regularly made to under a wrap? Is it the seller? Is it the maybe the existing lender, or at least a portion of the payment to the existing lender? Or is it like a loan servicer, or how is that normally structured?
So I've got a couple of different answers for that. So a typical investment strategy is a subject to acquisition by the investor. They're just taking over the note, and that seller is now gone. They're not owed any money. And they turn around and the disposition is seller finance wrap. On the acquisition side, I'm not ever getting a loan servicer in place. The seller usually doesn't care about, hey, who's going to receive the payments, et cetera. So I'm making those payments directly over to the underlying mortgage. Just set up my bank on auto pay, and my payment goes out to Freedom Mortgage or whoever it is. And then on the seller finance side, especially if you have a end user seller to an end user buyer, the seller is going to say, hey, if I pay the buyer, how do I know he's paying the mortgage? Buyer's going to say, hey, how do I know the seller is going to pay the mortgage? I don't. So then we get a third party loan servicing company to come in. They'll receive the payment from the buyer, divvy that up, pay the underlying mortgage what they're owed, and then send the overage over to the seller for their cash flow portion. Personally, I try to avoid the loan servicer on the disposition side if possible, but they're not expensive. I think $30 to $35 a month, and they take care of that. And they also take care of escrow accounts and payoff numbers and things like that. So they're helpful.
So in setting up the payments on a wrap agreement, I guess there's a few different structures. What are you seeing as far as, are most wraps on with just a seller, initial investor acquisition from a, mom and pop seller, for example, on that type of transaction, are the payments normally just what we would call mere loan payments, where you're just, paying the lender? Or have you seen like more hybrid things where it's like, okay, we're going to pay some to the mere loan, some to the seller? What are you seeing on that side of things? And when would the different type of payments apply?
I'm kind of smiling a bit because this hybrid mortgage wrap has come up recently. I'm trying to steer people away from it, but that's a fantastic question. So on my sub-2 acquisition, I'm mimicking everything with the underlying loan. So when my promissory note just has P&I in it, principal and interest. As the underlying loan taxes and interest escrow changes, then mine changes. So I'm just mirroring the loan on the first acquisition side. On the seller finance side, what we're doing is I've got a new note. So let's say there's $200,000 owed, but I've sold it for a $300,000 note. Then they just owe me on that $300,000 note, and then I pay what's owed on the underlying mortgage. Again, as that mortgage company says, hey, escrow has changed, I receive a letter, obviously, in regard to that. And then I send them a letter say, hey, escrow has changed, and here's the reason why. So I'm still just mimicking that underlying T&I aspect of it. On the hybrid, it's difficult to, I guess, discuss in easy, simple, short terms. But an investor will get confused. They'll say, all right, this fellow owes $165,000 on his mortgage, but property's worth $265,000, and that's my purchase price, and I don't want to bring any money down. So I've got $165,000 sub-2 acquisition, but now another $100,000 seller carryback. I don't like that. What it's doing is taking a mortgage wrap and dissecting it into its separate parts, and it should just remain a mortgage wrap. So we have a $265,000 mortgage wrap loan. So if I wanted the payments to be the same as the 165 mortgage, I can gear that into an amortization table so that my $265,000 loan has a $165,000 payment. So you're really, like I said, you're dissecting a mortgage wrap and breaking it up in two parts. And then I get to draft up two sets of loan documents and get paid more money. So I'm advising my clients to mash that back down into a mortgage wrap and not a hybrid that we're seeing.
Yeah, because then part of the transaction is a wrap, and part of it is separate financing otherwise. Yeah. So yeah, you're right. I mean, why would you break it up into two components? Just do a $265,000 promissory note, figure out how much the amortized payments are on that first position loan, and structure it that way as just one note. Makes sense. Yeah. Now, in that case, though, who would the payments be made to, right? I mean, you don't want it to go to the seller, because the seller may not, deliver them to the lender, or do you say, well, part of my payment goes to the lender, part of it goes to the seller? Or do you say, well, we're going to put a servicer in place and then the servicer just divvies it all up?
Either the second or the third.
Okay.
I suggest that the payment to the underlying mortgage be made, and then if there's a payment separate and apart to the seller. For some reason, with these hybrids that I'm seeing, the 100,000 or whatever seller carryback is usually 0% interest, and so they've just negotiated where, hey, carry this for 1, 2, 3 years, and then we'll pay you a lump sum at the end. I don't know how or why that's occurring. It's actually a little bit of the chaos theory going on right now, and I'm trying to mash it back into normalcy, but we'll see how it goes. And then, like you said, a loan servicing company in that situation is probably going to be the best bet.
Yeah.
Alan, by necessity in a wrap transaction or a subject to deal, the seller's still around. The previous parties still involved, whether it be on the loan. And one of the ways, and we'll get into talking about the due on sale clause, but one of the ways lenders typically know when a property is sold is a change in insurance. So let's talk about property insurance. This is an important part of the equation, but often part of the equation that's left undiscussed because everybody just wants to talk about payments and loans and everything else. How do you like to structure property insurance in a wrap transaction?
So fantastic question. On my presentations, I always say the due on sale clause, most talked about, least seen issue in the wild. Insurance is least talked about and most seen issue or problem in a wrap. So we've bounced around over the decades in regard to how we do this, and what we've settled upon is the seller is going to terminate their insurance. The buyer is going to get new insurance. You are going to use a insurance agent that is fully experienced on these types of insurance policies, because it is tricky how the declaration page is drafted up and sent out to the mortgage company. But what my folks tell me, and I'm parroting their words, is buyer is of course the insured. Seller is going to actually take two roles as the additional interest and the mortgagee. The lender is going to be the mortgagee also. They have to see their name. And then you've got your insurance in place. It gets shipped up to the insurance company. They say, okay, good, buyer, there he, or borrower, there he is. And here we are, we're good. And the insurance is in place. We use a couple, 3 different insurance agents that when the mortgage company gets confused, they step in and actually fix. And that's the part that's critical, because when you mess up the insurance, that's going to cause the mortgage wrap to, as you say, it's most often the reason for it to fail. Forced place insurance is going to come, payment's going to go up. They're going to do title searches, and they're going to start saying, hey, we're in default here.
Very interesting. All right, so let's talk about the most talked about part of the transaction, but the least likely to occur. And you mentioned it, the due on sale clause. We know contractually that's the potential looming nightmare outside of that. But let's just start kind of with the basics here. Can a wrap transaction trigger a due on sale clause?
So it can and does every time. So I had to count up how many wraps we have done for some litigation one time. And we're north of 15,000 wraps over the years and years. Out of 15,000, we've had 4 situations where a lender called the note due based upon the due on sale clause. And it's usually because of some silliness with the parties. They're contacting the bank and literally saying, hey, I sold this property. I've got some questions. One girl actually took her mortgage wrap documents into this small bank. She had a home equity loan, and she put her loan documents down and said, hey, I sold this property that had a home equity loan, so I want to get a home equity loan on a new property now. But at any rate, due on sale clause is the right for the lender to call the note due, make it so that all the payments are due lump sum in the event you sell their collateral. The thing is they A, don't find out, and B, don't care. So the new Texas legislation that went into place they thought about making it so that the lender had to sign off and approve a mortgage wrap transaction, and they declined to do that. So it remains a don't ask, don't tell type transaction in which the payments continue to get made and lenders don't care about the transaction.
So you kind of described what it means to call a loan due and what the due on sale clause is. In practice, for an investor looking to get involved in wrap transactions and subject to, what does that process look like in practice? And what can the parties normally do to kind of handle or prepare for that potential fallout on the front end, on the planning side of things?
So I do advise my clients that, hey, there is a due on sale clause. It's lawyers talk about possibilities, not probabilities. Is it possible the note can be called due? The answer is yes. So I tell my clients, hey, prepare, and the only way to fully prepare is to have the funds to pay off the mortgage. Now if I wasn't being recorded and this wasn't going out to the public, I would talk about a secondary method that we hear of being used, in which the property can be deeded back over to the borrower and then show that to the lender. And now the due on sale issue has been resolved and cured. I'll leave it to the imagination what we do with that deed thereafter. But that's another fix which we've actually employed a few times. But strictly speaking, you need to be ready to pay off that mortgage via selling the property, refinance, or coming with the cash to pay the mortgage. But again, 4 out of 15,000 times, I haven't done the math on it. Seems like that's a small percentage. So it is a low risk.
Is there, and now it hasn't happened all that many times, as you've said, but in the times that it happened, is there a common theme or issue that presents itself to the lender that causes it? Or is it, I know it can happen really for any reason, so long as they have the contractual right to do so.
So our 4, I can't remember the fourth. One was the girl who took her documents into the bank, which I thought was cute. One was a seller was actually mad and was doing what I say, pulling the pin and hugging your enemy, wanted the lender to foreclose on the property. So they were asking the lender to, in fact, do that. And the other one was kind of a weird situation. The condominium regime went bankrupt, causing all the legal descriptions to change. And so all the lenders had to go and do a title search to make sure that they were squared away on their collateral. And one of them said, hey, we see this wrap, so we're going to call it due. I forget the fourth was unknown. And the reason is it was about $40,000 that was owed, and the investor paid that off.
So recently, it was brought to my attention, this consent order out of Colorado dealing with subject to transactions in which the Colorado Attorney General pursued a number of sub 2 investors for failing to comply with Colorado's disclosure laws with respect to what they call equity purchases. So it basically, Colorado has a law that if a loan is in default or in foreclosure, and somebody's going to go and purchase it subject to, and reinstate and do all that, and then take title to the property, that they have to provide a 3-day right of rescission, along with, and the statute's vague, but they have to fully disclose the nature of the transaction, whatever that may mean. But nevertheless, they have to fully disclose the nature of the transaction, and they have to provide a 3-day right of rescission. So they were not providing the 3-day right of rescission in that case. Is there anything in Texas similar to that in Colorado, as far as what must be disclosed if you have a property in foreclosure and you're going to do a subject to transaction?
Yeah, absolutely. That Senate Bill 43, and we actually worked with the Senate on trying to get this in place. It was kind of funny. Three sessions ago, the senator that was backing the bill asked for all the big bank lobbyists to come and assist her in drafting up some mortgage wrap legislation. Now, understand what I just said there. Big bank lobbyists to assist on mortgage wrap legislation. So it didn't work out in the first session, didn't work out the second session, third session. They got it through. But we have a 7-day notice before closing. If you don't provide that, and that's called the 5016 disclosure, which is a reference to the Texas Property Code section. And all it is the nuts and bolts of the mortgage, the insurance, the taxes, all contact information for the mortgage company. If you don't provide that 5016 within 7 days before close, then a borrower has a right of rescission. And this is why I said the Senate bill is pretty toothy, because that right of rescission continues forever. So if you have a 25 years left on your sub 2, you get down to year 24, and litigation occurs because maybe you're trying to foreclose or something is going on. And this person lawyers up, and we go back a quarter century and say, you didn't file the 5016 7 days before. We're saying we rescind the contract, give us all the money back that was paid, et cetera. So it's problematic. So yes is the answer. Now, I'm curious about the Colorado. Texas looked at a rescission right, but the functionality, the reality of that is you close, reinstatement is paid. A couple, well, I guess not a couple mortgage payments, but reinstatement is paid. Then you say, hey, I want to go ahead and rescind this deal on day 2. How do we get our reinstatement dollars back?
No, I think it's you have to give them a right of rescission when you enter into the purchase contract is what it is. So the purchase contract, has to give them the opportunity to sleep on it for a few days, and then they can rescind it. So it's at the time that the purchase contract signed. But yeah, that's a good thought, because you're right. That would create some major problems if that, you know, and where that also would come into play. And you know, right now I'm seeing a lot of activity and communication regarding this is being on the eve of foreclosure. And so now the investor is like, okay, I'll help you out. You know, the only way to stop it is to reinstate or whatever the case may be. And, you know,
yeah, what if you're 2 days before the foreclosure date?
Right. Yeah. And you take a flyer, you reinstate, and then the seller's like, yeah, I'm out. Although I think, and I haven't, you know, fully I mean, I read the statute, but I didn't fully digest it. I think there might be a provision in there that says that although, you know, good luck getting it from them, but that the buyer would have to pay back anything that the seller has put out in that, 3-day period. But, good luck with that. I don't know what that would look like. So
we discussed that with the Texas folks. And so I said, hey, sometimes we're closing 7 days before. And so they said, okay, if it's within 7 days, then provide that notice, and they'll have 21 days right of rescission. And I kind of like a dog hearing a weird noise. I turned my head. I said, well, that doesn't fix anything. That causes more problems. So we haven't seen anything occur in the wild yet that causes that problem. But it is an issue. And we, after closing, we can pause for a few days, and we in fact do. If we're 2 days before foreclosure, we close, we send the reinstatement, we pause and make sure that we get something in writing from the lender that says foreclosure didn't occur, because sometimes they accidentally foreclose after in fact receiving the reinstatement. So we don't disperse seller proceeds, we don't disperse any proceeds whatsoever. We disperse the reinstatement, pause, get confirmation foreclosure. And so what I contemplated was the same type of pause if we have a 4-day notice and wait 3 days and then show the closing actually 7 days after notice, but haven't had to deal with it yet.
All right, Alan, we've spoken about the documents needed for a wrap transaction. We've spoken about insurance. We've spoken about the due on sale clause. We've gotten into the wrap agreement. We're all excited. Things are going great. And then we have a default on the loan, and it could be a default on any of the loans. So what happens in a wrap transaction when we have a default on behalf of the borrower? How is that handled transactionally, and how's that handled in Texas?
So the seller is going to have right of foreclosure, just like any bank. Here it's 20-day notice and then a 21-day notice, and set it up for the first Tuesday of the month, which is today. So you can pursue that foreclosure in the event of a default. But usually what happens on my seller finance wrap transactions, I'm making a phone call out and saying, hey, what's going on? I try to evaluate if it's a temporary or a permanent issue. and if temporary, do some loss mitigation efforts with them, let them repay a little bit over the next several months, what have you. If it's permanent, then we try to essentially negotiate a cash for keys and get a deed back from them, a deed in lieu back from them. The mortgage wraps that I've closed, maybe we've had 20, 30 defaults. Only one has had to go through a full foreclosure. All the others have been negotiated out through loss mitigation or cash for keys.
So what happens if the default is with the original senior loan, but not the wrapped loan? Is it all made in event of default? So an event of default of ones and an event of default as the others, so they can pursue their rights and remedies?
Yeah, it would be. So I buy from seller. I go seller finance. I'm not paying Wells Fargo for seller. They are going to be able to foreclose against me themselves, but also Wells Fargo can come and start their foreclosure proceeding. The new laws in Texas provides that if in fact I do receive money from this end buyer, that is now trust funds to be held for the payment of the underlying mortgage. If I fail to do that, it's actually a criminal offense now. And that's what the legislature wanted to do. People were taking advantage, getting hundreds of these types of transactions, collecting the money from the end buyer, not paying the mortgage, and making millions of dollars in wrongful dollars. But now, if you do it, it's quite toothy. You got some criminal action be brought against you.
So, well, that's interesting. Holy whoa! So if you are a seller and basically, let's say there's 100,000 in equity. So, you're going to sell the property for 400. First is at 300. There's 100,000 and some investor comes and says, hey, I'm going to cut you a check for $50,000. And then I'm going to wrap that first and make your loan payments. And if there's a default on that, then you as the seller have to basically take that $50,000 and write a check to the lender. Otherwise, you can potentially be charged criminally. Is that accurate?
The seller wouldn't be subject to it unless they're an investor and have more than 3 per 12-month period.
Oh, okay.
Yeah, the average seller just doing one, their homestead. Also, the homestead is exempt. So in theory, you could buy 4 homesteads a year and then sell them, and you're not going to be applicable to the law. But so the seller wouldn't be required under that trust fund act, but investor is.
So the investor that's having to obtain a loan originator or have the transactions handled by a loan originator because they're doing more than 3 in a rolling 12-month period. And if their end buyer comes forward, pays a big chunk of change to purchase it, then they have to hold that money or write a check to the lender, or if there's a foreclosure and potentially be subject to criminal charges otherwise.
If that payment is going to be a situation where now the underlying mortgage, if the payments weren't applied to the underlying mortgage, would be larger than that new mortgage, I could see where that would be required to be held in trust and therefore paid to the mortgage company. But if it's not, if there's just a bunch of equity that you're creating in this transaction, I don't think those would apply to the trust requirement.
Oh, okay. Understood. Yeah. So if you're I see what you're saying. So if it's money that you're receiving that really should be paid to the lender because there's no equity, et cetera, then that should go that way. And I could see where the, AG's office or the regulators would be looking at this saying, man, like you said, you could line up 50 of these, receive a bunch of money from the end buyer, let them foreclose, and then the lender is the one taking the loss while you're walking away with a big chunk of change in your pocket, right? I mean, they don't want that type of situation, obviously. So makes sense. And
yeah,
it sounded worse at first. I was like, oh man, there's a lot of risk in Texas on these transactions.
Yeah, so, and that was the impetus for the legislation, was protecting those people and also protecting the big banks.
So does Texas have anti-deficiency statutes?
When you say anti-deficiency, deficiency judgments?
Yeah. So in Arizona, if anybody, whether an investor or homeowner, if they go and they obtain a loan against a single family dwelling limited to or utilized as a single one family dwelling, that's kind of the definition. If they obtain a loan to purchase that and there's a foreclosure, whether or not it's an investment property, primary residence, whatever the case may be, if the lender lends money for that particular purchase, they can never pursue the borrower for a deficiency. They're just out. They're out that money. So it's a pretty strong consumer protection statute. Does Texas have something like that?
It doesn't. They call Texas a debtor state just because the collection laws are so difficult. But lenders do have right of deficiency judgments against borrowers. So we don't have that. I didn't know that about Arizona.
Yeah. Back in, I did a lot of consults, dealing with foreclosures and stuff. And it's pretty amazing the protections that are given to consumers or even owners, borrowers on single family residences here. It's pretty significant. So,
Alan, just briefly, what does foreclosure look like in Texas? What kind of time period would an investor expect to see from kind of start to finish?
If you sync the days up so you're hitting the first Tuesday, you can get one done in 41 days because you've got the 20-day notice and the 21-day notice, but usually takes 2 months to sync all that up and hit that first Tuesday. It's relatively simple. And I always say, when you're foreclosing as an investor on a seller finance, just be a very nice foreclosing lender. We can stop any foreclosure for a temporary period of time, minimum 60 days, sometimes as long as 12, 14 months. So don't cause your borrower to go lawyer up. Be nice, be honorable, see what's going on and work with the fellow, loss mitigation, et cetera. But if you do have to foreclose against some dishonorable borrower, then it's pretty easy.
Very interesting. Well, Alan, we really appreciate your time being with us today and talking about wrap agreements. Tell our listeners how they can find you, how they can connect with you.
So easiest ways, head out to our website, which is ceshker.com. So CESHKER.com. And then our email address is assistant@ceshkergroup.com. And I do consider myself to be a complete wrap nerd. I actually have an online wrap university tool coming out in January. It's going to kind of take the place of my in-person wrap university presentations, which is a big 4-hour presentation. So we're going to come with that online. But if you got questions about wraps, I'll listen to you all day because, like I said, I'm a wrap nerd and been that way since about 2003.
Awesome. Well, we really appreciate your time, Alan, and look forward to doing it with you again.
All right. Thanks very much, y'all. Appreciate it.
All right. You have
Thanks,
a good
Alan.
one.
Yeah.
All right, everybody. Thanks for joining us. That is our episode today. Join us next week at 10 a.m. Mountain Standard every Tuesday. Next week, we're talking about breaking down wholesaling and novations. If you wanted to know everything you needed to know about wholesaling and novations, Sean and I will be talking about it in detail. Make sure to join us. We'll see you guys then.
Have a good day, everyone.